collect those items 1379, 1380 from Deputy Bashmakian, please. All right, the record should reflect that each of the jurors has had the opportunity to view both 1379 and 1380. Mr. Neufeld.
Yes. And remember when I asked you at the very beginning of your testimony, Professor, whether or not you recall Mr. Rubin's testimony that the evidence gloves that he examined were 15% smaller than the new Aris Light Extra Large gloves. Do you recall that?
No.
You're,
Overruled.
it's 15%.
15 is what I read.
15, a page.
My recollection was 10 to 15, and on that basis, I prepared a way to show both 10 and 15%, or 85 or 90% of the original.
Okay. Did you prepare transparencies which reflect these gloves if they were 10% smaller and 15% smaller than they are in their new condition?
Yes.
And how did you do that, sir?
I prepared yet another master of the left glove by putting a ruler next to it and then using a variable enlarging, reducing copier, not my own. I do not have one of that nature yet. I'm expecting one shortly. I set it at 90% and simply made, again, a red transparency that I could first check the ruler, which is quite faint, and see that it is exactly 90%. In other words, 100 centimeters on the smaller one only is 100 millimeters is only 90 millimeters on the original. And so it is a right exactly 90% as I read it. And that was just to show the reduction by placing the red transparency over the original to see how much smaller it would be. And that is the figure I would give to the evidence gloves because I've examined them. The gloves on my pictures are 10 inches, the actual gloves I have, and 90% of that is 9 inches, and the evidence gloves are 9 inches. So I think it's 90% and not 85. But I also prepared the 85, which is, of course, a 15% reduction, and I would say simply that it goes from a man's size to a lady's size. It's very much smaller. But either way, it's an incredible shrinkage.
Okay. Can you, is it possible, the way you have done the transparencies on the photocopying machine, is it possible for the jurors to actually compare what the Aris Light Extra Large glove looked like before it was, had blood put on it in this case, in your experiment, and what gloves that are 10% smaller would look like and what gloves that are 15% smaller would look like?
Yes, I'm sure they can. They just did it before. I watched them.
All right.
So this is 90%. And this is 85.
Your Honor, I would ask that the two reduced versions, the 10% and 15%, be marked 1381 A and B. And is that for the left hand that you have first?
Yes.
Your Honor, I think for the purposes of this experiment, one hand should be adequate. So we'll do it just for the left hand. And I would ask Your Honor at this time to be able to pass that around to the jurors as well.
Have you shown those to Ms. Clark?
Oh, sorry. Which juror? One?
Juror number 1.
Okay. You have a sidebar while they're doing this?
All right, Deputy Bashmakian, would you hand that back to Professor MacDonald? Excuse me. Yeah. And Professor, may I see that, please? Thank you.
May I continue?
2 seconds.
Okay.
All right, Professor. Thank you. Mr. Neufeld.
Thank you. Professor MacDonald, in your expert opinion, and based on the experiments that you conducted, could the Rockingham glove and the Bundy glove be smeared with, could the smearing of the Bundy glove and the Rockingham glove with blood on the evening of June 12, 1994, account for a 10 to 15% shrinkage in those gloves?
Overruled.
I can't imagine it's at all possible, no.
Now, let me ask you one other question, not involving these gloves, sir. Did you hear FBI agent Bodziak's testimony this morning and yesterday regarding the color changes that bloody shoe print stains will undergo during the course of time?
Yes, I did.
And did you hear his testimony in which he said that whereas a glob of blood will turn from red to black or dark brown to black, a light blood stain will not go through that color transformation, but instead will simply fade and get lighter and lighter? Do you recall that testimony?
Yes, I do.
Is Agent Bodziak right scientifically, sir, when he says that?
Scientifically, I wouldn't say so. Maybe that's what he observed. I don't know what he had his thin blood prints on, but that has not been my experience, and I have them back in the 60s that are thin blood prints, and they're still dark. They didn't fade.
Could you please explain very briefly to the ladies and gentlemen of the jury what is the biochemical process that occurs that causes bloody prints, be they globs of blood or light bloody prints, to go from red to dark brown to black?
Well, the color portion of blood, the red portion, is hemoglobin, and as it oxidizes, it gets darker. And it doesn't matter whether it's a thin film or a thick film, it will get darker. I do not know of an instance where it has disappeared, except in some of my cardboard, the silverfish have eaten it away, but chemically, it doesn't disappear.
Thank you very much. No further questions.
All right, ladies and gentlemen, we're going to take a brief recess at this time just to change exhibits, and I'm going to ask you to step back in the jury room. We'll take about 10 minutes. 15? 10 minutes? All right, we'll take about 10 minutes. All right? All right, let the record reflect that we've been rejoined by all our jury panel members, that Professor Herbert MacDonell is on the witness stand undergoing cross-examination by Ms. Clark. Ms. Clark.
Thank you, Your Honor. Good afternoon. Good afternoon, Mr. McDonald.
Afternoon.
Now, the gloves that you performed your experiment on were brand-new gloves, is that right?
Yes, the
Okay.
gloves that I received.
As a matter of fact, showing you, sir, 1378C. No, I'm not. Yes, I am. There's a tag on that glove?
Yes, there is.
That's a tag that would be like on a brand-new glove, is that right?
Yes, that's the way I kept the right and the left separated without having to open envelopes. This is the right glove.
And when you got the glove, was it still in its plastic packaging, sir?
I believe it was, yes.
Now, the crime scene gloves that you examined were clearly not new gloves. Isn't that right, sir?
Oh, that's true. They were well worn.
And the gloves that you tested, being brand new, were never rained on, correct?
Not that I know of, no. They
They
could
were
have
in
been
their
repackaged. I'm not sure it was the original package. I've had them in and out of plastic protecting plastic bags, so I don't honestly know if it was a brand-new package I got them in when I received them, but they were wrapped up.
Okay. And they appeared to be brand new to you, didn't they,
They
sir?
were definitely brand new.
Okay. So they'd never been, as far as you could tell, they had never been rained on,
No. I couldn't
snowed
see
on,
that. No,
sleeted on.
no.
All right. They appeared to you to be pretty pristine. Would that be a fair statement, sir?
Very much so, yes.
Now, you picked a certain amount of blood to pour on the gloves to do your experiment. Can you tell us why you picked that particular amount?
That's what a vacutainer contains. I felt it would be adequate, and I was giving the blood.
Okay. It was your blood?
Yes, I didn't need 25 milliliters. I didn't think.
All right. Do you know, sir, precisely how much blood was on the Bundy and Rockingham gloves?
No, I do not.
Okay. So this was just kind of a random selection of an amount of blood to put on there.
No, it was what I felt would be an adequate volume to smear all over a surface. And as it was, it only took 2 out of the 9 milliliters, so it was certainly more than adequate.
All right. Now, you smeared it on with your latex glove, correct?
That's correct.
You don't have any reason to believe that blood was smeared in that fashion on the Rockingham or Bundy gloves, do you, sir?
No, I'm sure it was not.
Now, do you hold yourself out to be an expert in glove manufacturing
Certainly not.
or in the process of leather treatment, leather the type being used to make gloves?
Well, I've tanned quite a few hides when I used to hunt as a child and boy, but not to make gloves, no.
Okay. And you heard, did you hear Mr. Rubin's testimony concerning the preparation of the treatment of glove leather for the purpose of making it less water permeable?
Yes, I recall that. I think it was referred to as naked leather.
Yes. Do you recall his testimony concerning the treatment of leather for gloves with by immersing them in chromium, formaldehyde, and certain oils to prevent rot?
No, but it sounds like a good procedure. I'm not familiar with it.
Are you familiar with the use of fat liquors and oils that are added to reduce the potential of shrinkage when the gloves get wet?
No, not at all.
Do you have experience, sir, in the weathering of gloves that strip the fat liquor and those treatments to prevent shrinkage?
No.
Objection, seems facts not in evidence as to these gloves as opposed to other types of gloves.
And do you have personal knowledge and experience as an expert, sir, in the manner in which stretchability will be affected by the weathering of gloves in which the fat liquor is stripped by being subjected to weather such as rain, sleet, or snow?
No.
Objection, Your Honor, there's no testimony on that.
And do you have any expertise or knowledge, sir, in the properties, the resistance that a glove will have? Strike that, let me start again. Do you have any expertise or knowledge, sir, in the decreasing ability of weathered gloves to resist shrinkage due to the strippage of the fat, liquor, and other treatment processes?
Objection to some facts not in evidence.
Well, the first part I understand, but the last part I don't. Could
Let me see
you
if-
break it into two questions, perhaps?
I'm going to try. Okay. Is it part of your fund of knowledge, experience, and expertise as a forensic scientist, sir, that strike that. Do you have experience and knowledge and expertise in leather gloves and the properties of their ability to resist shrinkage after having been subjected to various weather conditions?
Not in their ability to do it. I observe it, but I don't know what it is that causes leather. I don't know if it's to shrink or to return to its original size. My experience with rawhide and leather is that if you wet it, you can stretch it, and then it will shrink back to the original size. So that is not shrinkage. That's just returning to status quo. That's why I wondered about your previous question. I'm still not sure, but I'm not an expert on glove shrinkage.
Okay. And I think what I'm getting at, sir, is this. As a glove ages, the treatment that had been initially put on it, do you have expertise in the field to know whether that treatment will wear off to the point where it will resist shrinkage less when subjected to wetness or water?
No, I don't have. Certainly if there's a treatment that's put on anything to prevent something, as the chemical, whatever it may be, is worn away or leached away for whatever reason, then the purpose it was put in there is going to be less achieved than it was when it was fresh, if that comes close to the answer to your question.
Okay, yeah. And that seems clear as a matter of common sense, doesn't it, sir?
Yes, exactly.
Without even being a glove expert.
Certainly.
Now, you do not know the history of the gloves that were found at Bundy and Rockingham. Would that be a fair statement, sir?
That is.
And the only pair of gloves that you tested were the brand-new pair of gloves that were given to you as provided by Richard Rubin, the glove manufacturer expert.
Yes, that's correct. They were not given to me directly by him, but indirectly.
And your knowledge is that they came from him. Is that right, sir?
That's correct. That's my belief.
Now, do you know anything in particular about the properties of these Aris-like gloves?
I never heard of them before, this case.
And can you name for us specifically any prior case in which you've come in to testify to a jury concerning the shrinkage of gloves due to the application of blood?
No, counting this one once.
Okay. And are you aware, not being a glove expert by your own admission, sir, are you aware of the variation in range of sizes of extra large? In other words, that there is variation in the size of extra larges.
Well, I don't know about extra large, but when I buy large, some of them fit, some don't, and they both say large, so I'm sure there is a difference in extra large as well. They're not all the same.
Now, do you have any gloves, sir, that are handmade?
I think I do.
Do you have any gloves that retail for $77?
A gross?
No, retail price.
A pair?
A pair,
No. I'm Scottish, no.
right? Are you?
Work gloves is about what I buy.
I'm sorry?
Work gloves for stacking wood. That's
Okay.
the most leather gloves I have.
Are you aware, sir, that that there is testimony to the effect that this type of glove retailed back in 1990 for $77?
Excuse me, Counsel, I think we're, remember there was a discount, there was a
Yes.
manufacturer's, and these were two pairs, wasn't it, for 77?
Oh, I'm sorry. Thank you.
Fifth, manufacturer's retail price was what, 50?
55?
55?
55.
Never buy retail.
That's right. Okay. Let me amend that statement, sir. Do you have any gloves that cost $55?
I hope not. I don't know. My wife frequently buys gloves for Christmas, and I hope she doesn't spend that much.
Does that impress you as a pretty expensive glove, sir?
I would say it's got to be a very nice glove, and these are nice gloves. I'm not questioning the retail price of them or the sale price, but I would not ordinarily expect to have a pair like that myself.
Now, you, of course, did not measure the Rockingham and Bundy gloves before the murders, correct?
No,
And you don't know what the condition of those gloves was with respect to the fat liquor and all of the chemicals applied to resist shrinkage prior to the murders, correct?
Chemicals applied to reduce shrinkage. Assumes facts not in evidence.
only to the extent that because of the wear, whatever was there originally wasn't there in the same amount that it was to begin with.
You
Because if
examined
they
them?
were worn, certainly things were missing.
So then, you would agree, sir, that prior to the murders, as worn as they appeared, there was some lesser degree of protection from shrinkage on those gloves?
Objection, assumes facts not in evidence.
I don't know. I would assume so, but I really don't know. If a worn glove loses its ability to resist penetration by moisture or whatever it is that could cause shrinkage over a period of time, then yes, but I really don't know. It would be logical, so I'll say conditionally, it seems that it would be less likely to resist shrinkage or anything else, staining, whatever, if the chemicals that are put in to prevent that are no longer in the same concentration.
Which is a likely thing to occur over a period of time and to be found in worn gloves such as these, correct?
It would seem so, yes.
Now, you did not measure the gloves in their original size just before the murders occurred, did you, sir?
No, I think I've already said that.
Nevertheless, and you're aware that these are extra-large gloves, the Rockingham and Bundy gloves.
They are so stated, yes.
Then presumably whoever wore them fit the size extra-large. That would be a fair common sense
That's
inference,
common sense,
correct?
yes.
Objection, Your Honor.
Overruled. The answer will stand. Next question.
Now, you do not know what conditions those crime scene gloves were subjected to before the murders, correct?
That's correct.
And you don't know precisely what conditions they were subjected to after the murders, is that correct?
Are you referring to immediately after the crime and before they're collected, or from the collection point on?
Well,
Yes. Before they're collected, I have no idea. From collection on, I assume they would be preserved in some forensic manner that would not further alter them.
okay, then you don't have any personal knowledge of either aspect of how the crime scene gloves were treated after the murder.
That is correct.
All right. Then you are not aware of the fact that the crime scene gloves were frozen and unfrozen a number of times.
I had heard that they were, yes.
And you do not know precisely how much blood was actually on them, is that true?
That's correct.
You said you measured the crime scene gloves, sir?
Yes, I did.
And you said they were 9 inches?
Approximately 9 inches in length.
And the gloves, the brand-new ones that you had, were 10 inches in length?
Yes.
Then you found that there was indeed a 10% difference between them, correct?
That's correct, yes.
Now, you testified to temperature and humidity based on reports taken that were generated from Los Angeles International Airport?
Yes, I did.
And
Do you have much more?
Not much. Not much.
Mr. Neufeld, how much more do you have left?
Oh, a minute.
Hurry,
Want to try?
let's try.
Okay. Okay, You attempted to duplicate the weather conditions stated for the Los Angeles International Airport for the night of June the 12th, correct?
Yes.
You did not...
Objection in the morning of June 13th.
Okay, June 13th. Showing you Peoples 60, sir. Peoples 44. Showing you that photograph, sir. You did not place your glove, the experiment glove, on soil, did you?
No.
You did not place it underneath a plant, did you?
No.
And showing you Peoples 169? Peoples 69? You didn't put your experiment glove on pavement on the pavement that had leaves on it, did you, sir?
No, I did not.
And you didn't put it on a pavement that had leaves on it with overhanging trees, did you, sir?
No. Well, actually, there were overhanging trees, but they were over the roof. So they were under overhanging trees. The laboratory's in the woods.
They weren't hanging over the glove, though, were they, sir? Well
Not
figured.
without the roof in between, no.
All right, sir, are you aware that the first time the crime scene gloves were ever measured was after they had been frozen on June the 21st, 1994? Were you aware of that?
No, I didn't know when they were measured.
Now, sir, you testified concerning bloody shoe prints. Let me just ask you a couple questions about that, if I might. So you're not testifying that shoe prints never fade, are you?
No, there can be reasons that they will fade, I'm sure.
Okay. And would you expect to find shoe prints that were not visible at the time of the murder to suddenly become visible in detail 2 weeks later?
In blood, you're referring?
Yes.
Not without some enhancement procedure. I wouldn't think they would just appear suddenly. They might be more noticeable, but if you're talking about stark contrast, I couldn't see how they would just suddenly appear very dark.
Okay. And let me ask you something else, sir. If after photographs are taken of a crime scene to depict all of the bloody shoe prints at a crime scene, and people walk through the crime scene after that is after it's broken down, and subsequently pictures are taken,
Objection beyond the scope. He just talked about a biochemical reaction.
and subsequently pictures are taken that show the appearance of shoe prints that were not shown in the photographs before the crime scene was broken down, will those shoe prints have any significance to you as a forensic
Objection
scientist
assumes
in
facts not in evidence. Move to strike.
the solution of the murder, sir?
I don't think I should generalize on that. I would certainly want to study it in as much detail as possible, but simply stated, shoe prints, heel prints do not appear unless somebody's been there.
Right. On a common sense basis, sir, if you see a somewhat faint shoe print in a bloody crime scene, would you expect to see a similar shoe print somewhere nearby?
Sustain. Sustain.
Okay, and the new gloves that you tested that were given to you initially by Richard Rubin, those were the only gloves that you tested in this case, correct?
That's correct.
And with your experiment, sir, you cannot tell us why the crime scene gloves are 10% smaller than your brand new gloves. Isn't that correct?
If they're the same size, they shrunk, yes. But other than that, no, I don't know what caused it.
Thank you very much, sir.
Mr. Neufeld.
You did give your opinion that whatever caused it, it wasn't the amount of blood that was smeared on it on the night of June 12th. Isn't that correct, sir?
No, if I'd have used 10 times as much blood, I could get 10 times as much shrinking, which is 10 times nothing is still nothing.
Thank
So
you.
I wouldn't use any more.
And sir, do you remember when Ms. Clark asked you some questions about shrinkage and new gloves versus old gloves? Do you recall Mr. Rubin's testimony that these gloves were made with something known as naked leather?
Yes,
And are you aware of the fact, sir, that these gloves did not have any Scotch Guard or other type of water-repellent chemical sprayed onto it?
that's correct.
No,
I-
section, let me see.
That's it. And applied to
Sustained.
it.
I mean, overruled. There's nothing, no testimony about spray treatment. Proceed.
And, sir, are you aware of the fact that between June 21st, 1994, and June of 1995, a year later, that these gloves were frozen and thawed many times in the crime laboratory?
I think I've been told that. I would not be surprised if they keep them in a freezer to examine them. They have to take them out.
And are you aware of the fact that notwithstanding that they were frozen and thawed and frozen and thawed and frozen and thawed repeatedly over that 12-month period of time, when the gloves were measured in June of this year, they were not any smaller than they were in June 21st of 1994? Were you aware of that? Oh, it does.
Sustained. Sustained.
Did you have an opportunity to see a diagram that was made by Susan Brockbank of the gloves in question in this case at some point during your investigation of this matter?
I may have, I do not honestly remember it.
Do you recall that the measurements that Susan Brockbank testified to regarding the gloves in June of 1995 were not at all different, were not at all more than 1% different in 1995 than they were in 1994?
Yes,
That's,
Overruled.
I do remember that. I believe I saw that particular testimony.
and finally, sir, Ms. Clark asked you a series of questions about whether you could replicate every condition that these gloves were in when they were recovered on the morning of June 13th. And she showed you a picture before, or asked you about, when you did your experiment, did you put the glove in soil? Remember her asking you that?
Yes,
Well, would soil make the gloves any wetter than the blood did?
Sustained. Sustained.
Given the fact that there is no testimony at all in this case about any precipitation or any wetness at the Bundy location, would putting the glove under a plant or a plant leaf make any difference in the amount of wetness that those gloves had as a result of being soaked with blood?
Objection, that misstates testimony.
Overruled. Overruled.
I cannot imagine how it would, no.
And sir, she also showed you the photograph of the way the glove appeared at Rockingham when it was collected on the morning of June 13th. Did you see that photograph?
Yes,
Do you see anywhere in that photograph leaves glistening to indicate that there's any moisture at all in those leaves?
Objection, Your Honor. Objection.
Sustained.
Would the fact that there is no moisture on those leaves or on that pavement do anything?
Misstates objection.
Assumes facts not evident in evidence, counsel. We've already talked about the dew point, we've talked about the humidity, we've talked about these other factors. The
Would the
jury's aware of
fact,
these things.
okay, would the fact that the glove in your experiment is not on pavement, but is in that glass contraption that you created, would that make any difference, sir, any appreciable difference in the results that you generated?
I didn't create it. I got it from the research laboratory. No, I don't think that it would.
Thank you very much.
One question. Sir, you testified that you were aware of the gloves, the photographs of the defendant in the gloves at the football games that were shown to the witnesses earlier or last week?
Beyond the scope of redirect, Your Honor.
Overruled. With
I-
some latitude, where are we going on this?
I have seen the
One
picture.
question.
You, pardon?
I have seen the pictures.
Did you test those gloves, sir?
Objection, Your Honor. Your Honor, she already asked him whether he tested any other gloves.
Sustained. He indicated no. All right, Professor, thank you very much, sir. You're excused. All right, ladies and gentlemen, we're going to take our recess for the afternoon as far as the jury is concerned. Please remember all my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case. Don't allow anybody to communicate with you. And what did I forget? I'm sure I forgot something. In any event, have a pleasant evening. except for those of you going to the dentist, and we'll see you all tomorrow morning, 9 o'clock. All right.
Declare the courtroom.
Jury is not present. All right, earlier today, Mr. Cochran, you gave the court a list of witnesses that you anticipated upcoming. Where are we?
Well, I did give you a list, and I ask Your Honor, in the interest of trying to move this case along, to assist us with certain of the witnesses. Certainly, Cheri Ray was in fact here, and I think I spoke with Your Honor before the break, and I excused her. She'll be back tomorrow morning at 9 o'clock. We do need Detective Van Adder. We do need Mr. Martz from the FBI.
All right, this is for testimony in front of the jury?
Yes, yes. We have further cross-examination of each of those parties, and that'll be still, and I believe, in our case in chief. We expect to call, excuse me, Your Honor. Excuse me.
I just passed it along.
I got a note that threw me off momentarily. We're going to need to, at some point after we deal with Detectives Van Adder and Agent Martz, we wanted to have the Fiata brothers, and I understand that my office has issued subpoenas for them today, an FBI agent named Michael Wax, W-A-C-H-S, Deputy District Attorney Dale Davidson. All of those witnesses relate to the same thing, statements allegedly made by Detective Van Adder. We may not need all of them, but after Van Adder testifies, we may need some of them. And what I guess I'm indicating to the court is I think we can pretty much wrap up the balance of our case and the surrebuttal, if not tomorrow, certainly by Wednesday morning. And then there's the issue of Agent Whitehurst. And we think that I don't know when you plan to read the various and sundry items, but we feel very strongly if there are specific links to this case involving Mr. Simpson, there are Simpson
Well, I'm
memos.
not reading anything until somebody submits an offer as
Right.
to...
Well, we had agreed, and Ms. Clark and I had agreed, and basically we want to start with Martz at any rate, so a lot of it depends on what how he responds. But we had agreed, Ms. Clark and I had agreed, I think, that we weren't going to make a proffer in writing necessarily because of the time. We wanted to move the case along. But if you want that, we can do it. We'll make it easier for Your Honor, we'll do that.
Well, here's the problem. You're going to make a proffer, you're going to ask me to read things and review transcripts and that sort of thing, so...
Well, I think we want to do is make some representations to you, and we will ask you to read certain things. We got more documents today from Washington.
Okay.
So you tell us what's most feasible, that will save you the most time, so we can get this matter over into this jury as soon as possible.
Well, here's the problem. I hear the name Whitehurst bandied about. I don't know what's going on, and I frankly try to avoid the news media reports on all of these things.
I understand.
And I have been successful, at least as far as Mr. Whitehurst is concerned. So, what are we dealing with here?
Well, let me have Mr. Blasier address that. He'll be dealing with that witness and Agent Martz.
Yes, Your Honor, there's a lot of material that we've been accumulating just in the last couple of days.
I'm sorry. If we're going to talk about this, can I get Mr. Kelberg here, because, or at least Mr. Hodgman, I was not present during these interviews.
Well, what we're about, okay. Yes, I think we need to do that since we're talking about a proffer here, and I sense a 402 coming.
Well, what I would suggest is, and we talked about this before, and I think we talked about it with Your Honor, that we would make a verbal presentation as to what we think is relevant, what we would like to call Agent Whitehurst for, and they could respond, and then if either side felt that you needed to read any of these materials, then we could direct your attention to whatever you need to read. There's no way you're going to read all of this, and I don't think you need to, quite frankly.
Okay. Mr. Kelberg?
Well, Your Honor, I have to confess I've heard very little, and I was not...
All right, Mr. Blasier, why don't you repeat your last 60 seconds worth of comments for
Yeah,
Mr. Kelberg?
my suggestion is that we both make an or verbal presentation as to what our offer is, and then if either side feels the need to have the court review any specific materials relating to what it is we're talking about, then we can direct the court's attention to that at the time.
In general, I don't have a problem with that. I think, number one, though, the court should be aware. I talked to Mr. Eglash, who is an assistant U.S. attorney who was one of the lawyers present during the interview with Dr. Whitehurst. Apparently tomorrow he anticipates receiving through overnight delivery a large number of documents. Apparently the defense has subpoenaed with at least one, if not two additional subpoenas today, certain records out of D.C. The records are going to be provided, as I understand, to Mr. Eglash for tomorrow. I suggested that Mr. Eglash come here at 8:30 tomorrow so that we could represent to the court what he represented to me, which is he won't have the documents till about 10:30, and he believes the documents will be divided into three categories. One, which is the documents they're willing to turn over to both sides as is. Two, I believe, is a series of documents which they would ask the court to review in camera to see whether or not they are relevant, and if the court deems them relevant, to turn over to both sides in the redacted fashion suggested by the agency. And three, a series of documents which they believe under no circumstances should be turned over for reasons that Mr. Eglash can much better express than I. Now that I've made this representation to the court, we might save time as to when Mr. Eglash should be here tomorrow, if that becomes necessary for the court's consideration.
Well, here's the problem. If he's not going to have the documents until 10 o'clock in the morning, then
And,
obviously we won't get to it.
and he indicated to me it's going to take them some time just to sort them into the appropriate package and have whatever paperwork they feel is necessary. He was hoping for a 1:30 appearance here with whatever materials he has been provided from Washington.
I don't have any problem with that. That may mean that if we're going to call witnesses, it might be Wednesday morning.
That's fine. Number one, has the court read any of the materials on Dr. Whitehurst which were submitted, I believe, on Friday, the 26-page memo, and there may have been other things I've lost?
No, I have not read anything yet. I have the original memo, I have a transcript excerpt, and I think there's one other item I might have in my package, I'm not sure.
Because I would ask, I think the court should read the 26-page memo. I don't think the court can get a flavor of Dr. Whitehurst without reading that memo, irrespective of what additional things either side may feel is necessary for the court to read in assessing what relevancy, if any, Dr. Whitehurst has to these proceedings.
All right, then I'll take that home if you don't object, Mr. Blasier, and read both items this
Only
evening.
with the understanding that we have a number of documents that relate directly to the Simpson case, which we think you should also review. I don't know if we may be able to make copies for those, and you can take those with you too.
I have no problem as long as I'm apprised which documents they are. I don't know if the defense is aware, I've been upstairs, so I have been receiving documents, copies of which I have been told have simultaneously been provided to the defense, not necessarily in the same mechanism, because I believe the defense has a lawyer back in Washington, D.C. who may be getting physical possession immediately. Ours is through faxes from the United States Attorney here, or from a representative of the Department of Justice who is out from Washington and is receiving them, I believe, in an office in Westwood. Long and short is, there are a number of letters that Dr. Whitehurst sent to the Inspector General's office. Much of the material has been redacted, just blacked out, but there are references in these letters to Simpson and Marks and so forth. If those are the letters, I don't know if you have them yet, I have no problem with the court reading those. We received some letters, I think also from the FBI today. I have not had a chance to review those in detail. I have no problem with the court reading those. And if the court gets the second transcript, yesterday's transcript, what I'm going to ask the court to do is read, I was the last lawyer to question. So my questioning, primarily, I had the opportunity to ask for clarification during the course of the examination by other lawyers, primarily Mr. Blasier and Mr. Neufeld. But my questioning is the last question, about the last 40 minutes. I'd ask the court to read that 40-minute segment of questions. I don't know how many pages it is, because that summarizes what I think the court needs to know about Dr. Whitehurst and his relevancy to these proceedings.
Well, let me get a running start with the items that Mr. Blasier suggests this evening. Believe it or not, I actually have other things to do with my life every evening.
I'm shocked to hear that, Your Honor.
Yes, all right. My koi pond pump died on me this morning, so
Hopefully not the koi along with the
if
pump.
I don't get a new pump, I'm in trouble.
I think you'll probably have one within an hour and a half.
No, it's a very special pump, believe me.
Your Honor, just when do you want us here?
Well, who are our next witnesses, Mr. Cochran? Let's assume that we won't get to the Whitehurst issue until tomorrow afternoon.
I would expect that. I think we're going to have hopefully Ms. Ray, Detective Van Adder. I'm trying to have Mr. Douglas check to see if Agent Martz will be out here. Those will be our next witnesses, it seems, and before we get to Whitehurst. And then the Fiata brothers, I understand they're here. The FBI agent, Wax, Dale Davidson, DA. We'd have enough witnesses in the morning to take care of, and then we can get to Whitehurst at the end.
Okay.
Your Honor, lest we be considered to have waived anything, I'm here to get a specific offer of proof, excuse me, Mr. Cochran, from the defense with regard to Officer Cheri Ray, who we received discovery for just this morning, and who I have had an opportunity to interview. And we have some vigorous objections to her testifying. So I don't want it to be assumed that because the defense wants to put her on, that the court is going to allow it.
All right, when do you want to do that?
I'd like to get a specific offer of proof from Mr. Cochran as to exactly what they would assume that Officer Ray is going to testify to, because the notes with which we were provided have a lot of buzzwords and inflammatory phrases that turned out not to be something that this witness could or would say that Mark Furman ever said or did. So I would like to start with an offer of proof from the defense as what they wish to call her for.
Mr. Cochran, I take it she's your next witness up?
Yes, you would be, Your Honor.
All right, what's your offer of proof regarding this witness?
Certainly, Your Honor. May I say one other witness that we potentially will want is mentioned this morning, Gary Sims also. And the reason I keep mentioning these witnesses, Judge, because if we don't get it, they're not here. We need to get some effort to get them here as soon as possible. Now, in responding to Your Honor's question, LAPD Officer Cheri Ray, as an offer of proof, we will proffer the following: that she was employed by the Los Angeles Police Department between the dates of January of 1982 and I think 1993. She's off on, I think, some kind of stress disability leave presently. She worked with and was a partner with on various occasions from September 1985 through about December 1988 with Detective Mark Furman. She is the first and only police officer we expect to call in this regard. She worked with him in West Los Angeles Station, and she has heard him.
She was his partner officer?
She was a partner on occasions, but she also worked. His partner most of the time was Tom Vitriano. She would work in another car and provide backup for those in the SPEW unit. And she has worked with him on occasion, but she was not his regular partner. But she knows him very well. She knows and has information regarding his use of the N-word repeatedly during this period of time. She has information regarding what she calls a code, a conspiracy of silence among the officers in protecting and covering for one another. She specifically uses a term, and I'm quoting so there'll be no mistake about that, "It's time to pencil fuck a nigger," which has to do with writing reports in a misleading way where they lie and change facts around to justify probable cause or to implicate someone who's otherwise innocent. She knows and can testify, as I said, about this major code of silence and something the officers routinely call test-a-lying, that they use the term test-a-lying. And then finally, that in 1988, her last day in that particular division, she worked with this particular officer, Furman, who a couple of days before that, she and he had won some kind of accommodation for an arrest, a grand theft arrest, and he pulled into the station at 5:00 a.m. on this date in December of 1988, said, I've been authorized to tell you what all the male officers out here think about you. He then launches into a tirade where she feels very, very frightened and intimidated and gets out of the car, leaves her in the car and goes in the station, and there's 2 more hours left on watch. But she understands him. In addition to that, when she heard him testify in February and said he'd never used the N-word in 10 years, she knew he was lying then, but I asked her, why didn't she come forward? She said, because we do no good. Internal Affairs would investigate it, and they do nothing about it. That, in fact, she did, in fact, report it later on, and they said, we'll get back to you. And she gave me the name of the officer, Manini, I believe it is, at IA, so they never even bothered calling her back. So she is off on some kind of stress disability leave now, but she was here today with lawyers and also with her defense rep. I think, Judge, that with regard to her, and anticipate any arguments of cumulative, this is a lady specifically, and you'll recall that we had the 2 ladies, we had Singer and we had Kathleen Bell, You said we could bring forward. We then had McKinney because of the tapes. We had Roderick Hodge, who was a suspect who dealt with the affront of Furman, and this is an officer who worked with him on occasion, backed him up, dealt with him specifically, and knows about the milieu of that particular division and the LAPD at that time. She knows a lot more, but obviously I want to limit it and can make it more concise. She could tell you a lot about the LAPD, and she doesn't make it just a few officers. She says it's many more than everybody wants to admit, and yeah, I don't plan to go very far afield, but I'd like to limit it to the things I've talked about here.
All right, Ms. Lewis?
Your Honor, that made me smile when Mr. Cochran said he wanted to limit it to what he had just discussed, which was everything in the book he could possibly hope to elicit from any officer. Your Honor, Cheri Ray was assigned to West LA Division for 3 years, 1985 to 1988. During that time, she told me today that she partnered at most, and she indicated that it was a generous estimate, at most 10 times with Mark Furman, because according to her, he worked the SPEW unit regularly and she did not work the SPEW unit. During that time, she indicates she recalls him using the N-word, but she doesn't recall any particular time that he did so. She specifically told me that he did not say, it's time to, pencil, fuck, and N-word. She cannot say that Mark Furman said that because she has no recollection of him individually saying that. She has a recollection, to her way of thinking, of various officers at West LA Division using racial epithets, and she has no specific recollection of any particular occasion or Mark Furman using them. So the defense proffer is based on someone who admittedly has a very shaky recollection with regard to Mark Furman's particular use, and admittedly had very little contact with him during what is a remote time period. And we're talking again about the 1985 to 1988 period, which is with regard to which the court has allowed abundant impeachment evidence. We have Laura McKinney's testimony that he used the N-word 42 times from 1985 to 1988. We have him saying it in his own voice, the best impeachment evidence the defense could ever hope to have admitted in a trial, the court admitted. We have Natalie Singer saying there's no good end like a dead end, highly inflammatory and prejudicial to the people's case, I submit. A statement of his that he made apparently back in 1987. Roderick Hodge testifying that he addressed him as an in January 1987. So we have all of these witnesses who have already extensively impeached Mark Furman on his use of the N-word. This witness adds nothing to that. It does not matter that she's a police officer. What they've done is put on extrinsic evidence that already impeaches him extensively on his use of the word, and now through Roderick Hodge, his addressing someone of the word. There is nothing this person adds that is probative on the impeachment issue, the very narrow issue that this court ruled was relevant for this impeachment to come in. Just because she's a police officer doesn't make her testimony any more probative on this issue. In fact, according to the defense, it would be less probative on this issue because of this conspiracy thing of theirs. At any rate, this woman's only knowledge of West LA Division, of LAPD, and of Mark Furman is 1985 to 1988. She's never seen him since then, except she did indicate to me that she, because she's been out from the department on stress leave, has watched the trial coverage extensively, including his preliminary hearing testimony last year, his trial testimony in March, the what I'll call Furman-McKinney tapes 402 hearing held before Your Honor, and all of the Furman witnesses who testified during the defense case. She's watched all of that. But her only personal knowledge as to anything said by Mark Furman dates back to 1988 at the latest, and she has very little recollection of it. There's nothing that her testimony can add at this point of time that isn't, almost as a matter of law, unduly prejudicial to the people, because it's the cumulative effect of this stuff is geometrically increased with every witness, and the last ones who testified did give it that extra inflammatory edge, which could very well, and indeed I believe has, caused at least some members of this jury to think far afield from the evidence in this case and to go far afield from the evidence in this case. We've demonstrated over and over again that no matter how many times this man used the N-word, no matter how bad a racist he is, there is no evidence that he had any opportunity to plant any evidence in this case or to falsify anything in this case or to do anything wrong in this case. So for the defense to attempt yet again to put on cumulative additional evidence on this point just to further inflame the jury now that there's been a little period of time between all the last witnesses and this witness they want to call now is simply not right, Your Honor. This is what 352 was enacted for, this exact type of prejudice. And here it's clear that there can be no additional probative value to be gained that could possibly outweigh the prejudicial effect. Just a couple of points, Mr. Cochran's offer of proof with regard to his speaking to her as a female officer, there's no relevance to Mark Furman's attitude toward female officers in this case. There's just no probative value there whatsoever, but to inflame the predominantly female jury that we have. So, Your Honor, that's it. Clearly, her testimony would be cumulative to all the other witnesses who've already preceded her on this identical issue.
Two quick points, Your Honor. Thank you, Ms. Lewis. The statement, the reason why I mentioned the statement with regard to the cover-up and the treatment of female officers, it corroborates exactly what Ms. McKinney said. Recall that a question was asked Ms. McKinney with regard to the cover-up issue, and the court limited us to cover-up vis-a-vis women officers versus men officers. It's entirely corroborative, and although they say that they gave up on McKinney, they didn't. They cross-examined her, they questioned her vigorously with regard, and I think it becomes very, very relevant. I also neglected to mention that she indicated to me that he did harbor a racial animus toward interracial couples. I mean, she does, in fact, buttress the other witnesses on various points, so whether Kathleen Bell or our Natalie Singer or whatever. It's not cumulative because, and the thing that's so relevant about this is a police officer, Judge. You know, how many times in a case are we going to be able to get a police officer who comes in and will tell us about this code of silence, or these officers test a lie, or that internal affairs doesn't do their job? There's a number of officers out there that are doing this thing over and over again. This is a police officer who is saying that. Now, I think that's very, very important in a case where we've said these things do in fact exist. There are many people who don't believe these things exist. And you know the problem we have establishing this. Miss Cheri Lewis stands up here now and says that, oh, there's no way he could have planted this glove. We're going to demonstrate this jury. He had plenty of time to plant this glove. We're going to demonstrate when and exactly when he could have done it, and that he has a willingness to fabricate, and that not only could he have done it, he did it in this case. So that's just rhetoric. I'm telling you what we expect to prove to this jury. And so this is why this is so relevant to us. I mean, I'm not telling you I want to call 5 or 6 other witnesses. This is a police officer in a different category that I think, and I told you everything she could possibly testify with regard to the racial animus, the use of the N-word, the attitude toward female officers, the attitude of the cover-up. That incident on December 1988 was particularly chilling to her. And but buttresses exactly what McKinney said in her testimony here. So it's very relevant. It's not cumulative. And this idea that this is so prejudicial to these jurors is an insult to these jurors. They've seen and heard everything in this case. They're going to be able to sift through this. And I think we have to also balance this with Mr. Simpson's right to a fair trial. The people have objected to every witness we've called during the course of our case. This is just another objection. And I would ask the court to allow us to call this lady. There's one other aspect of her testimony I would like to bring to the court's attention with regard to a 402 that I'd like to bring also at some point.
One other aspect? Well,
Yeah.
we might as well deal with it now.
Okay. She has pending a matter in Orange County, Your Honor. She has a lawyer here, and it has no relevance at all to this case. And it's a matter involving a child custody matter, and I don't see any basis for that at all. I understand, and also, Ms. Lewis, I understand when talked to her about a Board of Rights hearing. I don't think you can get into the Board of Rights or this other matter that's pending in Orange County. There's no convictions or anything of that nature. So I want a 402 with regard to that also.
All right, Ms. Lewis, those 2 last issues that Mr. Cochran raises.
Okay, and the last one first. Apparently she does have felony charges pending in Orange County. Trial, according to her counsel, is set as 0-10 on October 16th. Clearly, if that's not a conviction yet, I don't believe we could impeach with that, though, frankly, my co-counsel aren't aware of that. I'd like an opportunity to talk to them, and because there may be something that would be appropriate to bring up with regard to that. And I don't want to be foreclosed from that just because we've gotten discovery at the last second and been forced to argue this at the last second before Your Honor. With regard to one thing... In fact, I'm just getting advice that it could very well be relevant, certainly to our bias and her reason for now saying these things when she did not come forth, to anyone in March, even though she heard Mark Furman's testimony and claims that he knew that was not true. Conspiracy and aiding and abetting child stealing, basically having to do with her grandson, I believe, her grandchild. While they're serious felony charges, I'm sure she doesn't consider them nothing, and there are serious conduct at issue
So
here.
having conducted jury trials as to those issues before, I'm quite well aware of how volatile those are.
Yeah, very emotional and volatile type of situation. In addition, Your Honor, this Officer Ray is not saying, cannot say, and does not say, and is not saying that Mark Furman ever planted evidence, ever falsified reports, ever manufactured probable cause, or that
No,
she ever heard anyone else.
No, this was the only thing I was asking you to address were the pending charges and the border rights issue. That's the only new issue that Mr. Cochran's brought up that I'm interested in.
Well,
hearing
Your Honor,
about.
these are serious charges that are pending against her, and the department apparently has stuff for which they have disciplined her, as well as additional stuff which is pending, and I'm not exactly sure of the nature of it. But that type of thing can certainly go to her bias. Whether or not we even would choose to attack her credibility is an issue that hasn't even been addressed yet, because we've only just recently gotten discovery on this woman and just, become aware, and none of us have had an opportunity to confer since the court has been in session with most of the lead trial lawyers on the case throughout the day. But it's clear that there are issues that would be raised, and we would not necessarily go without cross-examination. This is far afield, Your Honor. And as far as corroboration of Ms. McKinney's testimony, does the court even want to consider that? That is so far afield, that the fact that she may have testified with regard to a sexist or female attitude, to have this corroborate that when that had nothing to do with anything. We're not denying that he used the N-word 42 times. It's on tape most of the time, and it seems to be the truth, and we're not seeking to dispute that
All
is
right,
the truth.
Thank you, counsel.
Thank you.
Your Honor, could I add to the court's headache?
I'm sorry. No, this is as to the 402 issue as to Cheri Ray.
No, I just wanted to add one other thing. When you have
I'm
an
sorry.
opportunity on Mr. Marks as a witness. And his availability.
No, you're disrupting my chain of thought here. I'm about to
I'm
rule
sorry.
on an issue, Mr.
I'm sorry.
Kelberg. Wasn't that apparent to you?
I wasn't certain whether the court had heard the argument and was satisfied now that it will be in a position to rule, or it was moving on to something else. I apologize to the court.
Let me think. Where was I? Do I need to hear the argument again? Never mind. No. No. All right. The objection is sustained for these reasons. I find the argument regarding the necessity of corroboration to have no merit. The racial animus of Detective Furman was corroborated by multiple witnesses who testified to the same thing. Also, his voice is on the tape, where that is abundantly apparent. There's no factual dispute that's even plausible at this point. It's a collateral issue. The proffer is remote, going to 85 to 88. It is clearly cumulative. The objection is sustained. All right, Mr. Kelberg, what was so important?
I'm sorry, Your Honor. It is only procedurally important. If the defense is contending that Mr. March should be called as a witness before the court rules on the admissibility of Dr. Whitehurst's testimony, the people say that that is an incorrect position. That, in fact, number one, the court limited the defense in their case in chief
Well,
to
Mr.
Whitehurst.
Kelberg, let's not even waste our time with this argument for this reason. If Special Agent Martz is in Washington, D.C. as we speak, and if we're not even going to get the Whitehurst documents in toto until sometime tomorrow afternoon, and we won't even be able to go into what relevance this might have at this point,
I agree, Your Honor, but
I'm not interested in hearing about Agent Martz at this time, only that I would ask that you make arrangements to put him on call so that he's available.
he already is.
All right, so he will be available on one day's notice.
I assume one day, obviously, he comes from the east, and as long as we can make flight arrangements to get him in here on the day, but he is cooperative. The attorney for the FBI is cooperative. We just have to notify the attorney that he is needed on a particular day, and he will be here. I'm sorry that I caused such a headache.
All right, next issue. All right, what purpose are we going to recall Detective Van Adder?
I think that Mr. Shapiro is going to be handling that. He's got further questions based upon newly discovered evidence. He has further questions of Detective Van Adder on cross-examination. He's still a witness in this case, and we have not arrested. I think we can do that. I mean, this is obviously, Your Honor, in this so-called search for truth, I would think that we certainly would have an absolute right to do that. The court is aware of this information. We expect to use it. I think it's our absolute right to recall him for this. He's the lead detective in this case. And are they saying they're not going to make him available to us? You're going to hide behind some kind of...
No, he's available.
All right, thank you.
He'll be available.
Okay, thank you. We'd like him tomorrow morning. Please,
But
I was going to call
I
Cheri.
understand there'll be a request for an offer of proof, et cetera, so we'll go through
We'll
this.
be glad to
again.
give him that. But so we don't waste any time, since I can no longer call Cheri Ray tomorrow morning, I'd like to have him here.
Okay,
Well, that's been true with every witness, Your Honor, so we expect it.
all right. Tomorrow morning, 9 o'clock.
I just wanted to point out also that the defense indicated they wanted to recall Gary Sims, and we looked at each other in wonderment as to what that was about. I believe he was just here. if I'm not
Refresh my
mistaken.
recollection, why did we want to call Sims back? I recall that he was released subject to recall.
Yes, Your Honor. As you recall, you reviewed this material in chambers, that Mr. Sims has notes that on July 17th and on prior occasions, he observed a wet transfer in the second sock that goes from surface 1 to surface 3 in areas where there is blood that he did DNA typing, which is consistent with Nicole Brown Simpson. So, once again, the absence, the wet transfer through from side 1 to surface 1 to surface 3,
Are we talking on the second sock?
second sock.
Is there a reason we didn't do this when he was here the last time?
Well, because on July 17th, when Dr. DeForest and Gary Sims did their re-examination of the socks, they documented this. This was the Brady material that you reviewed and Mr. Hodgman showed you. I realized it was confusing because they gave you unlabeled pictures for the longest period of time. But I think that's pretty clear. Obviously, if the same transfer mechanisms existed on the second sock that did on the first, that goes substantially towards the defense theory as to how blood was planted on the socks.
All right, here's the confusion that I have, Mr. Scheck, as to that issue. Wasn't Mr. Sims just here, and wasn't that information already given to you prior to that?
I asked to if you recall, I asked to make him my own witness, and the people objected.
That's right.
And then you
I
said,
recollect. Okay.
we have to recall him. Now, what I would do, perhaps, if they want, is I will call Mr. Sims this evening at his home, and if we can work out a stipulation to the prosecution as to what his testimony would be, and we could write that out, that might save us all some
Okay,
time.
I do recollect at this point that there was an objection to going into those areas on the scope objection. Ms. Clark?
Yes, if I could be heard on this one, Your Honor. First of all, this would not, as I understand it, be proper rebuttal, because we presented nothing in rebuttal that goes to this issue. That's first of all. And I think that one's clear factually as a matter of record. Secondly, that means that it should have been presented in their case in chief. And the stain that they're talking about was observed by Henry Lee and by Mr. MacDonell. Why they did not elicit the testimony from those people, I do not know. But they indicated that they were going to rest conditionally upon the court's determination of the admissibility of the Whitehurst issue, and nothing else. And we asked the court specifically if they were limited in their conditional reopening to that issue, and the court indicated that it did.
All
Now,
right.
with respect to
Hold on. Okay, what we'll do is, Mr. Scheck, Mr. Neufeld, put it in writing what it is you want to present and why it wasn't presented earlier. All right?
Your Honor, there's one other item.
Yes.
You may recall that when
Is
Mr.
that a
Pro...
candy bar wrapper?
Well, no, it's a syringe wrapper.
Okay.
On April 11th, 1995, when I, in the company of Joel and Demetrius and Bob Blasier, interviewed the nurse, Mr. Paratus, at the infirmary at the police department headquarters, we asked him which syringe he used to draw blood from Mr. Simpson on June 13th. And he opened the drawer and he showed us a syringe, and he gave us all the specs on the syringe. And it's a Becton Dickinson 10 cc syringe with the calibrations right on it. We went out and we purchased these with the hope of obviously introducing them when he took the witness stand. He's not taking the witness stand, as you know. He had these same syringes with him when he did the demonstration for Mr. Goldberg. However, you can't see the actual syringe in frame. I mean, you know it's a needle, but you can't see the calibrations because the syringe is being held too far away.
Well, let me jump way ahead of you, Mr. Neufeld. What you want to do is introduce that syringe in front of the jury. So we can do this one of two ways. Either the prosecution can stipulate that that's the syringe that is in use at the Parker Center Infirmary, or you'll have to get somebody from Parker Center to come over and say, this is the syringe we use.
Well, just so you know where we stand on this, I already gave one of these to Mr. Goldberg with the hope that he would agree to a stipulation. Otherwise, what I might have to do is, I want to avoid calling either Mr. Goldberg or Mr. Blasier, because they were the ones who were actually there and know what he said. Now, it may be that they're using different syringes now at Parker Center. I don't know the answer to that question. But the easiest thing would be simply to stipulate, and otherwise we will have to call additional witnesses, you're right. And I want to avoid that. That's all.
But see, here's the problem. As a matter of evidence, how do you propose to do that by other people's statements?
Well, no, I can call, one thing I could do, if I can't get the stipulation, is I would call, first of all, I could call Hank Goldberg as to what kind of syringe Mr. Paratus was using in that demonstration he did on July 27th at his house.
Not necessary. You can call Oppler.
No, Oppler won't know the syringe, I'm afraid, and I already asked Ms. Ramirez, I think her name was Ramirez, whether she remembered it, and she didn't. So they don't have the specs on it. Mr. Goldberg was the person who had frequent conversations with Mr. Paratus, and would be the person who, you know, did this with him that
Well-
day, frankly. He directed it.
As a matter of hearsay, contemplate how you're going to do that. All right. I would suggest try to stipulate first, and if not, call somebody from the infirmary as to what's in stock. Because that's B&D is the standard medical supply.
Oh, no. But what I'm explaining is that they actually, is that Mr. Paratus showed us the packaging so we know which model number and everything else. And this is, in fact, an exact duplicate of the needle described by, of the syringe described by Mr. Paratus.
All right, well, maybe I'm not making myself clear at this point. Okay, we'll be in recess, 9 o'clock tomorrow morning. Thank you all.
There's now those witnesses, Judge, so I want to,
I'm sorry?
you know those witnesses, the Fiala brothers, Dale Davidson, Wax.